Good evening, this is Laws 12062. It's week number 8. Tonight we're discussing the topic of court-annexed dispute resolution, and from your text, chapter number 6, pages 151 through to 202. It's also feedback week. You would have noticed the big red icon inviting you to have your say. And to supplement that and encourage some discussion, I'm happy to receive your emails if you wish to make any comment or ask anything privately. But I'll also open up a UCrew page, and on that I will invite people to make comments. Tony, I'm just going to get you to mute your microphone if you would.
Sorry.
No, you're right. And so it's an opportunity for you to tell me about any problems that you may have encountered, any difficulties in relation to the assessment regime, anything that you want to consider about what we've covered, recommendations on what we should cover in the future, things of that nature. So I'm keen to tell me about the course and tell me if you are gaining the sort of practical and academic knowledge and experience that you'd hope to obtain. So that's important. I want to ensure that it's a worthwhile course. Now, speaking of assessment regime, that brings me to the take-home examination. And as you know by now, what I have in mind for you to do is to have 4 or 5 days, or whatever you need, to complete that task. What we've done in the first assessment is given you a taste of what it's like to be a practitioner in ADR. The second assessment is all about you being a practitioner in a law context as a lawyer, giving advice to participants, clients, about the ADR process and essentially trying to determine what is the best way to deal with a specific issue. And many of the things that we've talked about in general terms will come into play, and certainly tonight's topic is relevant in that regard. So when I went through university in the 70s, it was pretty simple. We had a dispute, we had to identify the dispute, provide a legal answer, and the only real practical side of that was in the last year where we had a moot assessment, which is where we had to argue respective positions. But things of talking about alternatives to litigation was not even on the radar, not even considered. And it needs to be these days. We need to talk about the alternative dispute resolution procedures that are available, talk to a client in terms of the advantages and disadvantages of particular types of ADR, talk about the process, the timing, the cost, the expectation on the lawyer, the expectation on the client, and be more specific in terms of referring to the client to ADR practitioners or dealing with a number of ADR options and providing clients with those advices in relation to cost, timing, and procedures and recommendations. So that's what the second assessment is all about. It really is an assessment piece that should only take you a day. So I hope that I've been quite generous in the amount of time which has been given, and I appreciate that many of you have other commitments, you've got work, things will happen. So it's not expected, I don't expect you to work 5 days full time on that assessment. It shouldn't take that long. But I would expect that you'll need to put in 8 to 10 hours at least, but that probably would be sufficient. And if you can identify specific places which might assist in the ADR process, real life places, so much the better. So it would be great if you made contact with people in the industry and said, look, I'm a law student, got this hypothetical situation, think this might be something that would be down your alley in terms of resolving if it was a real dispute. Are you happy to give me some advice? Are you happy to give me some feedback as to cost, time, appropriateness, feedback as to what type of procedure? You might talk about arbitration, conciliation, mediation, the whole range of things are available. So I encourage you to get out there in the real world with this take-home examination. And that's a big reason why it is a take-home examination and not an examination that you would sit in a set time. It's meant to be far more practical, theoretical bent, but far more practical in its application than a theoretical examination. And I think I mentioned to you at the start of the course, this is not introduction to course, so I'm not asking for essay-style answers. I'm asking for real-life solutions. And I think that you'll all be up to that, and hopefully you can look forward to it as if you were acting for a real-life client in relation to an issue of concern. Are there any questions about the take-home examination? Have I confused you from those comments? Is that all pretty clear? Come in live, ask a question, or use the chat facility. All right.
That all sounds good, John.
Yes, John?
No,
Right,
I just said it sounds good. Yeah.
Oh, good. Thank you. All right. So, yeah, sorry, John.
Oh, sorry, John. Is it just the one question?
Yeah, sure. Oh, sorry. Is it just the one question? It'll be convoluted. So there'll be a central character or some central characters facing one or probably more than one potential dispute situation. Things might be collapsing around the protagonist in life, and a whole lot of issues are being raised. So you'll be asked to consider a number of different scenarios, but around a central character. I hope that makes sense. All right, thank you. Have a look at my comments about presentation of the paper. I think you probably would have picked up that I like the paper to be professionally presented. I really don't like sloppiness. I want it to be real life. I want you to think in terms of what you might expect a person who's charging $400 or $500 an hour to do by way of presentation. And think of it in terms of how you as a client would feel if you received the paper. Is this showing value? So we're not saying that charging $400 is over the mark. We're not saying that it's outrageous, quite the opposite. What we're saying is that's real life, that's what lawyers charge, and you need to ensure that you're at that standard so that people are seeing value in the $400. So yes, it's expensive, but I can see where this lawyer has earned his or her money as a result of the work that's been presented. It looks professional. It looks like it's up to standard. That's what I'm looking for. So have a look at the guidelines that I've introduced into Moodle. Make sure that you follow some of those basics. Have a look at my sample document. It's not the best document in the world. It's okay, but it provides you with some guidance and some insight as to what I have in mind. Make sure that you use footnotes where appropriate, or the same rules that apply in relation to any other paper apply in relation to the take-home paper. And that's another advantage of having a take-home paper as opposed to a paper that you would sit during exam week, in that you can be appropriate, careful, and accurate with your referencing. So by all means, in your paper, feel free to be innovative. Use flowcharts if you wish, use diagrams, use photographs, anything that you think will convey the information in the best manner and in the most professional manner. Make sure that you follow it up with anything that might be appropriate. For example, and this won't go to any word count, if you think that it needs to have something attached, which is a brochure, information guide, page from a web address of an ADR practitioner, any of those sorts of things, feel free to add that in. But I'm really looking at your content, and I'll consider the material that you've added to it as well. All right, so thank you very much for that. So tonight's really all about court-based ADR. A few general comments, and I take it that you've all done your reading. But it's fair to say that there are a wide range of processes which are available, and they operate across a number of jurisdictions. So many of the ADR processes do operate within the court, and I should say tribunal systems as well. Many of them operate externally, and some are a hybrid between the two. In some instances, we have court dominated or annexed processes which are referred externally. So many disputes now are in fact resolved through ADR before the matter comes to a court or tribunal system. And there is an increasing tendency to require mandatory ADR before you are even able to file material. And you may have come across that in the context of family law. So be aware that if your client requires action or assistance in relation to a parenting issue, then you wouldn't file at the Federal Circuit Court immediately, or you wouldn't file at the Family Court. You would go through the mandatory ADR processes, and you'd probably want to know about that before we get to week 12, so have a good look at that. So there is a greater awareness also and desire from practitioners to embrace ADR, and that wasn't the case in the 70s and 80s. Many processes now require specialised knowledge of relevant ADR practitioners within the court or tribunal settings, and that would be something that you'd want to consider if you're referring a client to an ADR process. What type of practitioner do you want to assist you as the mediator, conciliator, arbitrator, whatever it might be, and do you require or do you think it advantageous to have that practitioner have specialised knowledge of the area of practice? So keep that in mind as well. Case management is something that we've seen on the increase over the decades. And by case management, I'm really referring to what the courts do to assist the process of ensuring that the matter proceeds in an appropriate way. And case management, I suppose, is really part of ADR in some ways. So think about case management and think about the Uniform Civil Procedure Rules at a state level in that regard. Many tribunals, QCAT included, are now adopting a philosophy which is built into the legislation, which is part of the structure of the tribunal, and that is that the dispute must be resolved in a way that is just, efficient, timely, and cost-effective. So there are certain tribunals and courts that will adopt that type of wording, and keep an eye out for that wording because it will have a bearing on the way in which the matter is ultimately resolved. So in short, ADR has become mainstream, and indeed it's become integral to the litigation process. Are there any questions from those opening comments that I've made? All right. Well, let's think about the specifics now from a federal perspective. You would have seen that the text commences with commentary in relation to the Administrative Appeals Tribunal, AAT, and you can see from the comments that what essentially is being discussed in that opening paragraph is what we would call a merits review. So the commentary is that officers of the AAT review administrative decisions made by Commonwealth Government, ministers, officials and authority. So the AAT reviews executive decisions, if we go back to separation of laws concepts. And it also reviews decisions made by some non-government bodies. Now, here is what tips you off to the fact that it is in fact a merits review, and that is the AAT decides whether a correct decision has been made or whether a preferable decision should be substituted in accordance with the applicable law. In this respect, the AAT will affirm, vary, or set aside the original decision. That is a merits review, making a preferable decision in relation to an administrative or executive context. We do a lot of that in the Queensland Civil and Administrative Tribunal. The fact that the name says it all as well, that it is an administrative tribunal dealing with merits reviews. So in that context, for example, in QCAT, I might deal with a case where a person who was denied a blue card administratively seeks to have that decision referred by a tribunal. The tribunal is QCAT, and I then, as the member sitting in that jurisdiction, will decide the matter based on what is the correct and preferable decision. Sounds a bit terrible to say that, but that's just the way the wording of the merits review is. So essentially, the person making the merits review will sit in the shoes of the person who made the original decision. It's not an appeal against that decision per se. It's a merits review, which means that we essentially start from scratch. And it's not a case of considering, like an appeal court would consider, whether the original decision was within the range and therefore will not upset the decision. A merits review is a hearing de novo. It's a hearing from scratch, from start. Okay, so that's the AAT regime. And Section 34A provides that the President may direct that alternative dispute resolution process is to be used by the parties. And the interesting thing about that wording is that the President may direct, not recommend or suggest, but direct that ADR processes be undertaken. Section 34D provides that the agreement is to be reduced to writing. And here's the interesting part about that. If the dispute is reduced to an agreement in writing, and that is an agreement between the parties through the ADR process, then the agreement is considered by the AAT, lodged at the AAT, and if the AAT is satisfied that the agreement is within its powers, then it may make its decision in accordance with the agreement. Now, what I take from that is this, that the agreement which is struck by the parties during the ADR process may or may not be accepted by the AAT. Firstly, the AAT needs to be satisfied that it has power to make the order, which has been arrived at by agreement between the parties. And then secondly, it needs to be satisfied that it may make the decision in accordance with the agreement. It needs to be satisfied that it is appropriate. Did I just put you on gallery view? Did I upload a paper that I wrote in relation to ADR and environmental law? If I haven't, I will do that.
Yes, you did.
I did that? Right, thank you. And in that, there was some commentary that I wrote about a decision of Judge Rackerman, I believe, where the judge received an agreement between the parties to an ADR process by way of an agreement as to an appropriate penalty to be imposed for breach proceedings. And in that case, His Honour ultimately did make the order which was consistent with the agreement made by the parties, but did so not because it was an agreement between the parties, but because it was the appropriate order to make. And the rationale behind that thinking was in parallel circumstances to criminal law proceedings or prosecutions following the following the High Court's decision recently, the prosecutor is now precluded from making a specific submission in relation to what is an appropriate penalty. Gosh, I hope that hasn't been too convoluted. I hope you've been able to follow that. So what that tells me is that in the AAT, a similar thought process needs to be followed, and that is this agreement an appropriate decision to make in the circumstances?
So, John, can I just ask, does that mean that all decisions are reviewed by the AAT?
So is that all agreements that are struck by parties during an ADR process?
No, all decisions that are made by the member.
Oh, I see. So I think what you're asking is that the only work of the AAT to do merits reviews?
Well, I'm just wondering really, when you say that the AAT will review a decision that has been made, is that the case for all decisions that are made by a member of a review board?
Okay. I guess there's probably two things that I've been thinking about. The first is the general jurisdiction of the AAT is essentially a merits review decision or jurisdiction. And that's one aspect of what we've been discussing. So it will make, that is, the tribunal will make the correct and preferable decision. That's one aspect. And the second is that the AAT has a considerable ADR component, and in that situation, if the parties come to an agreement, they will then present it potentially for an order to be made by the AAT, but the AAT will not necessarily make the order in accordance with the agreement struck by the parties. So that's the second concept that I've been talking about. I hope that makes some sense.
Yes, that's clear now, John. Thank you.
Yes, thank you. And Tony's made the point quite rightly that the review jurisdiction will only come into effect in circumstances where a party requests the review. So there's not an automatic review of an administrative decision. AAT, as is the case with other tribunals that are involved in review matters, will only consider the decision if the original decision is challenged by a party relevant to the proceedings. Okay, well, thank you for that. Now, Fair Work Act, Commonwealth, provides for extensive ADR processes. I would recommend that you look at the Fair Work Act in that regard. The commentary is quite good. It's quite short, but it essentially provides that certain dispute resolution processes are available to resolve grievances, and those grievances can be referred to mediation, conciliation, or sometimes even arbitration. And in the context of unfair dismissal claims, if the parties agree, then Fair Work Australia will conduct a private conference, and often that's done through telephone. There's a lot of urgency about it. And if Fair Work Australia is not satisfied with the outcome, it must issue a certificate to that effect pursuant to Section 369 of the Act. And I think there was a question or comment came in. So Annie has made the point, said, is this along similar lines of the recent decision in Director Fair Work Building Industry Inspectorate against Construction, Forestry, Mining and the Energy Union, 2005? Proctor has an article about it. Thank you for uploading that, Annie, about it being a landmark decision because the parties can no longer expect the court to have regard to the terms of an agreement. Now, if I'm looking around because I have that issue of Proctor, I think that's the one that, Annie, you're referring to. Was it page 40 that you were saying that that article was on? Because I had a quick look and I couldn't see it. Oh, there it is. Page 30. So that's the article that Annie is referring to. And I must confess I haven't read it in full. But the conclusion is that special leave was given in relation to that decision. I'll have a look at that in more detail and I'll provide a response on you, Crew. But thank you for raising that, Annie. Annie, do you wish to make any comment about that?
Hi, John. It's Annalie.
Hey, Annalie.
I was just reading it and trying to understand if what they're talking about in this article, they're talking about the penalty that the parties have agreed to and that the court doesn't have to have regard to the penalties agreed on between the parties. Would that relate to us here with agreements in general, or is it specific just for the penalty section of it?
Actually, no, you're right. I can see it now.
I misunderstood the article altogether.
And what it is, it's an extension of the principle in the Barbaro decision. That's what I was trying to think of before. So what the author in this case is talking about is somewhat similar to what I wrote about in the article that I prepared, and that is how the thinking behind the High Court decision in Barbaro against the Queen is now being extended into different areas of practice. So Barbaro's decision, which is 2014-305 ALR 323, in short, can be summarised this way, that a prosecutorial authority or representative of that prosecutorial authority is not at liberty to submit as to what is an appropriate penalty. The prosecutor in a criminal trial can now point the court in the direction of appropriate or relevant decisions and can indicate that in comparable decisions, certain courts came up with certain penalties, but they can't go further and say, therefore, in this case, we submit that this particular penalty is the appropriate penalty. So that's what Barbaro is all about. And in the paper that I wrote, I indicated that that line of thinking has now been extended to prosecutions under the Planning and Environment Court jurisdiction, even when the parties have, through ADR processes, come up with their own agreement. That is also consistent with the line of thinking it would appear in this Fair Work decision. Thank you, Annalie, for bringing that to our attention. So from an ADR perspective, I think that is relevant. It's relevant in the Fair Work jurisdiction. It's relevant in the Planning and Environment Court jurisdiction. And as we've discussed, it's relevant in the AAT jurisdiction, in that essentially it's one thing for the parties to come up with an agreement, but it's another thing for that agreement to be made the subject of an order. The court will have, in certain circumstances, particularly where it's a prosecution, an overriding discretion and authority to make the decision that it believes to be appropriate in the circumstances. I hope that that hasn't been too confusing. Can I just have a gallery view? Are we having too many puzzled looks, or we've got some thumbs up? We're okay? All right, a few thumbs up, all good. All right, thank you. So that's the AAT, that's Fair Work Australia. Family law. Been a lot of changes from an ADR perspective in family law over the years. And what we've seen is, of course, and I've alluded to it tonight, in family law jurisdiction, now, before one can proceed to initiate proceedings in relation to parenting, there is a requirement to undertake mandatory mediation. And that mediation would be conducted through the services of a family dispute resolution practitioner. Now, a family dispute resolution practitioner usually would be a lawyer, but certainly would be a person who holds qualification as a nationally accredited mediator, and then a further qualification to be registered as a family dispute resolution practitioner. So I'm probably one of those rare people I am nationally accredited as a mediator, and I have obligations to update my accreditation through CLE, etc., on a 2-yearly basis. But I'm not a family dispute resolution practitioner, so I can't issue the certificate, the Section 60 certificate that is necessary in order for the party to proceed to litigate a matter, should they wish to do so, in relation to parenting in the Federal Circuit Court, which is formerly the Federal Magistrates Court, or the Family Court. All right, so the point that I'm trying to make on that is you can't advise a client to immediately initiate proceedings in relation to parenting without getting that certificate first. There may be an exception to that, and that is in relation to urgent recovery orders, which can be prosecuted even in a state magistrates court. All right, so that's the regime for family law jurisdiction and ADR process. Family counselling is also mentioned in that context. It's slightly different type of ADR. Family counselling is where parties are assisted outside the judicial process to resolve personal issues in relation to marriages or arising out of divorce or separation. So if you're acting for a party who is in that stressful situation, then you might want to consider a few different types of ADR process. You might want to consider a process that involves a family dispute resolution practitioner, and you might think about the advantages and disadvantages of doing so. you might think that one of the advantages of doing so is that if the matter is resolved, great, it can then be the subject of consent orders. Or if the matter is not resolved, at least your client will then receive, presumably, a certificate to enable your client to litigate the matter through the Federal Circuit Court or the Family Court. So you might think that's one reason to take your family dispute to an FDR practitioner. Maybe you would prefer to see your client undertake family counselling, either on their own, his or her own, or perhaps in conjunction with his or her partner. You might think that's a more appropriate ADR process to undertake, and give some reasons as to why family counselling, as opposed to resolution through mediation involving an FDR practitioner, is preferred way to go. Or you might think that different options would be beneficial to your client in that situation. Perhaps just negotiation involving two lawyers and two clients, or perhaps involving the local dispute resolution mediation service might be a better way to go. So think about those different options that would be available to you within an ADR context in family law. Any questions about any of that? Okay, thank you. We'll move on. Federal Court of Australia, specialist proceedings there. Matters can be referred to mediation or arbitration. And if you've got a dispute which might involve the Federal Court, then you might want to think about and give advice to your client in relation to the benefits of pushing for mediation as opposed to arbitration. All of this, of course, would require some explanation as to what these terms mean. At a state level, the District Court, Supreme Court rules are relevant, and of course the Uniform Civil Procedure rules are relevant as well. So the UCPR has provided a framework for mediation and other ADR process, and there are some overriding obligations in that regard. All right, so there are certain directions conferences in the Magistrates Court regime as well, which I'll get you to read about in your text. Then, of course, we get to QCAT. And in the QCAT regime, from an ADR perspective, we have three different types of process. One is a pure mediation, standard mediation. The second, which is probably the most common, is a conciliation, which we call a compulsory conference, or COCO for short. That's the second type. And the third type is really interesting and innovative, and Senior Member Peter Stilgo, I think, was instrumental in proposing and putting this in practice. And it's what we call a hybrid hearing. So if, for example, we have a tree dispute or perhaps a dog destruction dispute in QCAT, the matter requires some urgency, and therefore we may not have time to go through and have a full conciliation or COCO followed by a hearing, but we kind of put them in together. And the way in which it's done in a hybrid hearing is this: the parties are asked to attend the hearing. The hearing is conducted. The member hearing the matter makes a decision, writes that decision, seals the decision in an envelope. This all happens on the same day. Then comes back and says to the parties, I've now made my decision. Here is the decision, but I'm going to give you one last opportunity to resolve this yourselves. You've heard the evidence. You've heard exactly what I've heard. I'm now going to invite you to talk about this, see if you can come up to with your own resolution, and if you can't, I will then read the decision, which is in this sealed envelope. And to assist you in coming to that decision, I will now stop being the member that's hearing the matter, and I will now become a mediator. Now, not a conciliator, but a mediator. You probably guess why it would have to be a mediation, because having heard the evidence and made a decision, it's entirely inappropriate then to give some guidance or assistance to the parties. So it becomes a pure form mediation which is designed to assist the parties to come to a resolution. If they can't, then the member hearing the matter will unseal the envelope, make a bit of a song and dance of it, and say, here is the decision. So that type of matter, it might be worthwhile just doing a bit of reading on hybrid hearings, but typically it might be in relation to matters which are urgent. Say a dog destruction case might be one instance of that. Any questions about QCAT jurisdiction, mediation, conciliation, or hybrid hearings? Perhaps I should just mention this. Mediations are the least used of the ADR processes, conciliation much more. COCOs are more common because members can provide some direction, some advice, some thoughts about likely outcomes, and can finish the process by making actual orders. Mediation is much more pure form, assisting the parties to come to a resolution. Mediations are typically used in QCAT for building disputes, but even that has been taken away from QCAT of late because now these mediations are going back to the Queensland Building and Construction Commission, the QBCC. Okay, so mostly QCAT is conciliation, some mediation, some hybrid hearings. Okay, I've done a lot of talking again, I'm sorry. Are there any questions about what we've talked about tonight? Because I'm just about, oh no, I was going to talk about planning and environment law. I'll talk about that shortly. Are there any questions so far?
It's Brad here. I have a question.
Yes, Brad?
In regards to the hybrid facilitation that you're mentioning, is there what safeguards are put in place to protect the parties from a conflict of interest? Because there's a crossover from someone who's made a decision. Any words can steer the direction of the parties to a decision that's already been made.
That's a really good question, Brad. It's an entirely appropriate question as well. All I can say is that the integrity of the member needs to be relied upon, and it is important that the member remains even-tempered and neutral in that mediation process, even though the member has heard the evidence and made a decision. I guess to some degree, there is a bit of acting involved, but that's nothing new. Acting's a big part of being a lawyer. I think we all know that. And your role as the mediator in those circumstances is to play deadpan, down the middle, don't give anything away, poker face, I guess. But at the same time, bearing in mind all those principles that we talked about with mediation. And what makes a good mediator? Well, being seen as someone's good mate. So the art of being a good mediator is being seen as your brand new best friend, to quote Professor Assman from QCAT. So you are not giving anything away, you're being neutral, but you're really encouraging the parties to come to a resolution themselves. So I hope that answers your question, Brad. Thank you.
No, good. Thank you, John.
All right, Tom. All right, well, just before we finish, I just want to mention a few things specifically about planning and environment regime. I think you know that I take that subject as well. So the Land Court deals with issues in relation to ADR mediation prior to hearing, and parties have the usual opportunity to resolve matters in an informal, without prejudice context. The usual rules regarding confidentiality apply. But in the Land Court jurisdiction, there are brand new practice directions. Practice Direction number 1 of 2015 was made on the 27th of July this year. And this is in the paper that I wrote, so I won't go into it in much detail. But essentially, matters which are referred to the Land Court can now be the subject of a without prejudice conference. Parties are required to attend. And the procedures in place in the Land Court are now more closely aligned to the procedures in the Planning and Environment Court. Practice Direction number 2, which came out on the same day in the Land Court, essentially deals with the issue of disputes relating to valuations, and there's different procedures that apply depending on the value of the amount, the value of the property in question. So I won't take that any further. I will just mention a few things about the Planning and Environment Court. As usual, in jurisdictions, you need to be aware of practice directions. So here, for example, is the practice direction number 2 of 2014. You can see my yellow highlighting the way I do things. And that practice direction deals specifically with ADR. The purpose is to set out case management procedures for the just and expeditious resolution of real issues in proceedings to a minimum of expense. And that particular practice direction sets out the procedure for applying for orders for directions about the future conduct of proceedings, and that has to be done within 6 weeks after institution of proceedings. It all happens very quickly, and ultimately there is a requirement for the parties to identify the issues in dispute, set out a dispute resolution plan, and then, depending on the nature of the dispute, to include draft orders which deal with issues like disclosure, exchange of list of experts, conduct of meetings, the ADR process to be chaired by an ADR registrar, etc. So if you do have the time, have a look for practice direction number 2 of 2014, which sets out those ADR processes and other processes in relation to a Planning and Environment Court dispute. The P&E Court, the Planning and Environment Court, is of course essentially part of the district court regime, in that a P&E judge is actually a district court judge. So all of the P&E decisions that come through that court will be from people that you might otherwise see in the context of the district court, mainstream district court. Okay. You've been very patient. You've been doing a lot of listening. Thank you very much. Unless there's any questions, any comments, we'll wrap it up for this evening. Okay. Nothing coming through yet. All right. Well, I'll stop the recording. Thank you very much.